Hello again, everyone. I'm Zachary Lawrence of Parkside Property Management. Welcome to the Landlord Tenant Radio podcast. I am here with my friend, mentor, and eviction expert, Dennis Block. Hi, Dennis.
Hey, Zach. You know, this is our second video podcast. Hopefully, it'll be a little bit more polished than the last one.
I was happy with the last one myself.
You were?
I'm very happy.
You were happy with yourself?
I was happy with myself. I was happy with the last one, and I'm going to be happy with this one. So without any further ado, this podcast is for landlords and tenants that want their questions answered under the umbrella of California law regarding the landlord-tenant relationship. Dennis, let me share something with you. We had a tenant pass away recently, and the way we found out that he passed away is because, number one, he didn't pay his rent. Number two, we served him with a 3-day notice. He didn't respond to that. So we went out, knocked on his door, and heard from one of the other neighbors that, unfortunately, this long-term tenant, quality guy, passed away. Can you tell us both the legal aspects and the moral aspects of dealing with a tenant that passes away who incidentally may or may not owe the landlord some money?
Well, let me first ask you, did the tenant give you a 30-day notice that he was vacating the premises?
That is a bad joke. That is a really bad joke.
But it's a good one. It's a little bit of eviction humor. Okay, when a tenant dies in the unit, a few things happen. Number one, if that's the only tenant of the tenancy, then the landlord can immediately take possession 30 days after the last rent was paid. A lot of times you have relatives that are trying to take over the units, but of course they don't have the right to do so. You had your...
I'm sorry, forgive me. Who is in possession of that unit where the tenant died during this 30-day period?
Technically, it's the estate of that tenant. However, that tenancy then terminates by its own accord 30 days after the last rent was paid. So a lot of times you'll have relatives that will try to take over a unit, especially if it's a rent control unit. But obviously the landlord can grant access to the relatives to get their stuff, etc.
Can or must?
Oh, must. You must allow them, assuming that they qualify as persons that are authorized to take the possessions. After the 30 days expires, then the landlord can change the locks. The place is his. Of course, he does have to comply with the law dealing with abandoned personal property.
Talk about that, please.
Well, if a property is abandoned, in this case, they're abandoned by the decedent, the estate has 18 days to claim the premises, to claim the property. So the landlord has to serve a written notice, and assuming that there was an administrator or an executor set up, you would mail that abandoned personal property letter to that person. They'd have 18 days to get the stuff. If the stuff is worth less than $700, then in that situation, the landlord is free to dispose of the items. If it's worth more, then technically the landlord has to hold a public auction, publish notice in a paper, sell the items, and then the proceeds of the items would go to pay for the sale and the advertising, etc. The rest of the money would need to go to the estate of the tenant. Mm-hmm. So that's the first issue about when a tenant dies in your unit.
So again, Dennis, technically the estate of the tenant is in legal possession between the 30 days between the time the last rent was paid.
That is accurate.
Okay, so the landlord has no rights to just use his key and go in.
Well, he can go in. I mean, he's allowed to check out the property. If there's food rotting in the refrigerator, etc., he would be able to take care of that. But technically, he doesn't legally possess that unit, even though he legally owns the unit, until 30 days from when the rent was last paid.
Does he still have to post a notice to enter, even though, in other words...
I would say yes, he'd have to post a notice to enter, and if there is someone from the estate, then yes, I would say that would be accurate. Okay. Now, the next issue that most people are not aware of is when a tenant dies within your unit, then unfortunately the landlord is obligated to tell any potential applicant who wants to lease the unit that there was a person who died in the unit. There's an exception to that. It's an odd exception, and that is if the person died as a result of AIDS, then for some reason, as the law is written, you do not have to inform any prospective tenants as to the reason for the death.
Okay, hold on for just a second. If the tenant dies in the hospital, does the landlord have a duty to disclose to any prospective tenants the guy that lived here died in the hospital?
And that's a great question. The answer is no, only if the death occurred in the unit. So I'm sure what you would be doing in a situation like this, if you knew that a tenant was pretty close to dying, I'm sure what you would do is invite him out to the lawn so that he would die on the lawn, and then you'd be okay.
Folks, this is what I've had to put up with for 25 years. Go ahead, Dan.
Yeah, but now you get to see his face. So in any event, now you see the pain that I'm causing.
Oh, my goodness.
In any event, the tenant, you'd have to propose for 3 years to any prospective applicants that the last person died within the last 3 years.
So if he dies inside the unit, you have to disclose. If he died outside of the unit, you don't have to disclose. And if he died of AIDS, you don't have to disclose regardless if he died inside or outside of the unit.
You're an expert in the law, young sir.
Okay. Now, we've had a tenant die in the unit.
Was it something you said?
And it probably was. It probably was. And, we had to get a hazmat team in there and get rid of the stench and all that's responsibility. Now, unfortunately, Dennis, that was our reality. Okay, we had to clean this place up, and that cost money. Okay, who pays for that?
Well, technically, the estate is responsible for reasonable cleaning charges, and that certainly would be reasonable cleaning charges.
Okay, now let's say that, for example, the tenant didn't have an estate. He was a pauper, okay? And now the landlord is stuck with this unit which he has to decontaminate, for lack of a better word. On whose dime is that?
Well, if it's just like anything else, if the person doesn't have money, then the owner of the property is going to bear the expense. Technically, you could make a claim against the estate, but if there is no estate or the guy's a pauper, then it's just a loss for the landlord.
Okay, Dennis, go ahead. Any other final thoughts on the case of the dead tenant?
No, I think we've covered it pretty well, and it's a nice morbid little topic.
Yeah, nice way to start the conversation, isn't it?
And it was your question, just I want everybody to understand
Thank you
that.
for throwing me under the bus. This is what I have to put up with, folks. Okay. All right, Dennis, you do... here's something I want to talk to you about, and then we'll get to the Q&A. Apparently, Airbnb is being sued by a management company, I think it's in Denver, because they're claiming that Airbnb is encouraging tenants to use Airbnb to supplement their income, and as a result, the tenants are profiting from that relationship. Care to comment on that?
Well, it's not just the tenants that are profiting from that relationship. You've got the company of Airbnb that's profiting from that relationship. And the truth of the matter is, every rental agreement, with very few exceptions, say that there shall be no subletting or assigning of the agreement. And clearly, every tenant who is doing that, where there's a written rental agreement, is in violation of that agreement. So the issue is, if their agent, their kind of partner in crime, is the company Airbnb, which is basically allowing this to happen, can they be held responsible on some theory? It's not a case that I would bring, but I could see some liability. Now, my understanding with Airbnb is that they're making their clients certify that they're truly the owner of the property, or that they do have permission to do what they're doing, which is to subrent the units. But again, I don't think they're taking it any further. So I'm not so sure that this lawsuit in Seattle is going to prevail. But I certainly think that Airbnb should shoulder some responsibility when they know that, in fact, their clientele is violating the terms of the rental agreement, and of course they're getting unjustly enriched by that as well.
Well, Dennis, I mean, Airbnb is a company that is not stupid. They're aware that the boilerplate language in leases claim that you cannot assign the rights to your unit to a third party without the landlord's written consent. So wouldn't any solicitation by Airbnb be a interference with a landlord-tenant relationship?
Well, yes, but again, where there has to be some contractual responsibility, and of course, Airbnb.
Between who and whom?
Exactly. They're going to say, you can hold me liable, Mr. Landlord, but if I have some sort of a contract with you, and I don't have a contract with you, and on that basis, we feel that we're shielded. That's basically going to be their argument. But you're definitely dealing that they're in an agency together, and I think it's incumbent upon them.
Who's in an agency together?
The lessor, the person who's subleasing the premises, and Airbnb, because they're using their site to gather their clientele, so to speak. So maybe on some sort of an agency theory. Again, I don't know how strong of a case it is, but I can tell you that we have been getting call after call after call, and this is just in the last 3 months, of tenants that are illegally subletting out their units, and landlords literally are getting, for example, in one case, the rent is $1,650. The tenant is sub-renting the premises on a monthly basis on Airbnb and other places for $39.50. And the landlord's is under rent control, cannot raise the rent, and of course has to pay the mortgage payment, has to pay insurance, has to pay real estate taxes. If anything's wrong with the unit, they have to, of course, fix it. And yet, look who's making more money on the apartment. Right. So this is just wrong, and we have been filing evictions left and right on this issue.
Are you also pursuing the tenant for the ill-gotten gains, if you will?
No. I've had a client ask me to do that.
Why not?
I don't see any basis, at least in terms of the type of lawsuit that we're bringing. We wouldn't have the right to ask. In an unlawful detainer, I can only seek the rent of the property per the rental agreement and also possession of the premises. Could there be some sort of another lawsuit brought for this unjust enrichment that the tenant's getting? And conceivably, yes, that you have to disgorge all the profit that you made. But again, it wouldn't be part of an unlawful detainer. And obviously, from my client's point of view, what they're looking for is to get possession of the premises.
Would you recommend to the landlords out there, Dennis, to add language to the boilerplate language that might already be in their lease about assignment and subletting to specifically mention Airbnb?
I think the language is sufficient if you say no subletting or assigning. However, I think it should be considered, and this is a really good idea on your part right now, that any advertising and any of these services, for example, Airbnb, shall constitute a material breach of the rental agreement and should be considered a non-curable breach, where if you do it, then your lease is terminated and we can evict you. I think that's great language. And you know what?
Would you please put that?
I'm going to put that in my rental agreement.
Thank you. And you're going to give me credit now for co-authoring that lease. Is that correct?
Ladies and gentlemen, I'm giving Zachary Lawrence the credit that he needs. Why he needs his credit, God only knows.
What else do I get around here? Thank you. Okay.
You get a car wash, maybe.
I get a car wash. Okay. On a rainy day. Thank you. Thank you. I appreciate that. Okay. All right, Dennis, you have an informative Q&A column in the Apartment Owners Association magazine. I encourage all of our listeners to join the Apartment Owners Association. I think membership is what, $70 a year?
$79 a year, regardless of how many units you
and if you
own.
can pony up to $79, Dennis will be happy to kick in.
No problem.
No problem. There you go. You're going to be flooded with calls in about an hour. Okay. All right, Dennis. Let's go to question number 5 here, because we covered 1 through 4 in our last podcast. The question reads: I have an applicant with poor credit, but the applicant can have a cosigner execute the lease. I did a credit check on the cosigner, who has impeccable credit. The cosigner lives in Nevada. Do you think this is a wise move?
I have had a client who's called me up with a similar situation like that. And I'm dead serious. What I say to the client is, let me ask you something. Are you standing next to a wall? And then the client will say yes. And I'm going to say, then you should take your head and beat it against it, because this is probably one of the most silliest and most unwise move that you can possibly make. Number one, my position is if the person who's moving into your unit does not have sufficient credit, then there is no basis of renting this unit out. To try to chase a cosigner is really a monumental task. Now, for example, if the tenant doesn't pay the rent, yes, you have a cosigner, but if you start an eviction, most people think that you can include the cosigner's name. After all, he did sign the agreement as a cosigner. But the truth of the matter is that is not an agreement that would hold the cosigner liable in an unlawful detainer action. In an unlawful detainer, an eviction lawsuit, you can only sue those people that are unlawfully detaining the premises. So in that situation, I can't sue the cosigner. I can only sue the tenant. I can get possession of the premises. I can get a judgment against the tenant, whatever it's worth, because we know he has poor credit. Now, if I did do this, my next step would be to serve the copy of the judgment on the cosigner, saying, you are now responsible for this judgment, please pay me. If the cosigner doesn't pay you, then what you're going to need to do is you're going to need to file a brand new separate lawsuit against this cosigner, and those are not inexpensive. You can go to small claims court, but in the question that you read, this person lives in Nevada. Even if I got a California judgment against him, to try to enforce that judgment in Nevada is a total waste of time. So on that basis, follow my lead. If the person who's moving into your unit does not have sufficient credit, please do not rent to him. Never take a cosigner. Now, let's pretend you've got, let's say a fourplex over by USC, and it's common that the parents are going to co-sign for the children. And assuming that the parent is local, you have a better chance at that. However, I don't recommend having a co-signer. Make the parent an actual tenant under the lease. They're not going to live there. I don't have to live there to be a tenant. I could rent units all across the United States, one in Miami, one in Chicago, but never ever step foot in the place. Make them a tenant, because you see, as a tenant, now we have the right to sue them in an unlawful detainer action. So
in California.
So what we're looking for right now is to get rid of the terminology cosigner. Everybody's a tenant, but obviously what we're really looking for is the actual person who's living in your unit has sufficient credit.
Dennis, if the cosigning parents are also living in the state of Nevada, aren't you faced with a difficult, aren't you putting yourself in a similar position even though that they're not a cosigner?
I agreed. So while I could sue them, I would have to serve them. I don't think it would be proper to serve them by serving them at the apartment unit, since they really don't live there. I'd have to hire a process server to go serve them in Nevada. But again, I'm still facing the same thing. I'm eventually going to get a California judgment. Yes, the people who are in California, I can garnish their wages. I can attach bank accounts. I can put liens on their real property. But what do I do with a guy who's living in Nevada? I'm going to have to first hire a Nevada attorney for a $4,000 or $5,000 judgment.
So the moral of the story here is, even if Mr. and Mrs. Smith agree to be named as tenants for their USC daughter's lease, and Mr. and Mrs. Smith live in Nevada, it's not a good idea to put anyone that is not going to be occupying the premises on the lease.
Absolutely.
Okay, thank you. We actually agreed on something. I'm beside myself. Okay,
let's move on.
Okay, question number 6. Is there a limit to how much I can increase the rent on a tenant once his lease expires? My property is located in San Diego.
San Diego. I love San Diego because that's a civilized place to own property. What I mean by civilized means that they do not have rent control. Any jurisdiction that doesn't have rent control is a civilized place to own and lease property. Places such as Los Angeles, Santa Monica, West Hollywood. Those are uncivilized
Beverly
places.
Hills.
Even Beverly Hills now.
Do you
They've
believe
changed
that,
their
folks?
statute.
Beverly Hills has rent control?
And they just made it much more stronger with regard to how much you can raise the rent for their...
What is it?
It was 10%. And now I'm not sure what the current rate is, but it's much lower than that. Plus, you can't just ask tenants to vacate in Beverly Hills. You have to pay them relocation money now. So even Beverly Hills. So the answer to this person's question is, how much can I raise the rent if I'm in San Diego? And the answer is you can raise it to whatever level you want. You can move it right to market level or you can go above. There is no limitations on rent increases if you're in a civilized area to own properties such as San Diego or Long Beach or Redondo Beach, or let's go down the list here.
Right.
Burbank, for example. Now, there is one proviso that if in fact you have a rent increase that is going to be above 10%, then you're going to have to serve a 60-day notice to increase the rent. So if it's 10% or less in any 1 year period, then you can do a 30-day notice. But if you are going to give above 10%, then it's got to be a 60-day notice.
Does that also apply for a single-family home?
That would apply to a single-family home, any real property in California.
I understand there's no rent control for a single-family home, but if you increase the rent above 10% and the tenant has lived there for longer than a year, you would still have to give them 60 days. Is that right?
Being there longer than a year has nothing to do with the equation.
Okay.
And so it's just how much are you raising the rent? And you are right, this applies to single-family homes, which are not under rent control. This is a state law which deals with the rent increase of any unit. Mm-hmm. Now, obviously, in a rent-controlled area such as Los Angeles, the most you can raise rent in any 1 year period would be 3%, unless you're paying for the utilities. I might add that Los Angeles City Rent Control just published their new allowable rent increases. So for the current year,
drum roll,
there is going to be a 3% rent increase. In other words, that it hasn't changed. Right. There has been years when it's been more, but they are adopting the same rules. So as of August 1st, 2017, if you're going to be raising the rent, then it's going to be a 3%.
3%. Plus, you can increase, tell our listeners, 1% for each utility that the landlord pays for, except water, and what about trash?
No, not trash. You're either talking about natural gas.
Except water and trash.
Right. Well, you're talking about natural gas or electricity. So you could get a total of 5% if you were paying those two utilities.
Very good. Okay, Dennis, explain something to me and to our listeners. If you have a home on a lot that is subdivided, and the lots have separate addresses, separate assessment numbers, separate everything. Bear with me. And there is a single-family home on, let's say, lot number 1. And there is a contiguous structure on lot number 2, which you decide to turn into an income property. Based on my description, are these units under rent control?
Well, a single-family home is not under rent control. That is that it is the only dwelling on that lot. So you're telling me that they have a separate assessor parcel number for each of those two lots. Right. If that's the case, even though they're contiguous, even though they're owned by the same owner, they're two separate lots, and therefore the house would not be under rent control. If, in fact, he was building a duplex on the other side, well, if there was already one structure on the other side and he built another structure, then magically both of those structures... Well, actually, no. If he was building onto that other house and making it into a duplex, then yes, then that would now become under rent control.
So it's the rule is 2 or more structures, income structures on a lot triggers rent control.
Well, not income, dwelling units.
Dwelling units.
Right.
Okay. That's
2
fair.
or more.
That's fair. Okay.
But how about this as an unusual situation?
Okay.
You have a single-family home that's on a property, only one house on the lot, and of course, it's not under rent control. because it's single family. You decide, and the zoning allows you to do so, to build a house in the rear.
Okay.
And by building that house in the rear, you now get a certificate of occupancy. Under the law, if you have a certificate of occupancy that was first issued after October 1978, your property is now not under rent control. So if I build a new duplex and the certificate of occupancy shows that it was built in 2017, we're not under rent control. But in this situation, if I build that rear house, I've got a certificate of occupancy after October 1978. That rear house cannot be under rent control. But you now have two homes on the lot, and now the single family residence now is under rent control because that property was built prior to October 1978.
Interesting. So structure number 2 is exempt because it was built after 78, but structure number one, as a result of the building of structure number 2, becomes subject to rent control.
Absolutely. So it is a quirky little area in the law.
It certainly is. Okay. How are we doing on time over here, Dennis? We've got a few minutes
left. We've got a
left.
couple more questions.
Couple of more minutes left. Let's do question number 7. I have to do some work in the parking lot. You also have to do some work in your parking lot, by the way. We'll get to that later. I have to do some work in the parking lot of my apartment building. This will require the tenants to park on the street for a couple of days. One of my tenants is threatening not to move the car unless he is given a rent deduction. Dennis?
A landlord has the right to make necessary or agreed repairs. And a tenant has an obligation to provide for access to allow the tenant to make the repair. In this situation, the repairs need to be done to the parking lot. In fact, we just did our parking lot. We graded it and we restriped it.
I still can't find a place to park.
Well, I didn't say I enlarged the parking lot, for God's sakes. I said I repaired it. Oh my God, do I have to deal with this guy?
It's called throwing good money at a bad situation, but go ahead.
But at least the lines were nice and white. You knew where you couldn't park because they were already occupied. But in any event, the tenant has to provide for access. So sometimes access means for example, that you have a plumber coming into the unit, the tenant has to open up the door, stand to the side, and let the plumber come in. That's allowing access. But sometimes access means that they can't use their parking spot. No compensation need be given.
Wait a minute. What about diminution of value? Hey, I paid for an apartment with a parking spot. You're taking this parking spot away from me. I would like to receive compensation for the diminution of value for the number of days that I don't have a parking space. Is that a valid argument?
It is not a valid argument. Whatever you would like is fine, but this is not what we like. This is what the law states. The law states that you have to give access. It doesn't state that because I gave you access and I moved out of the way of the plumber and allowed somebody to be in my house that now I was inconvenienced and therefore I'm entitled to compensation. That's basically what you're saying with the parking spot. So in that situation, they have to allow access. So if the parking lot needs not to be parked in for 3 days,
all right,
then in that situation, that's what it just means.
Okay, so Mr. Landlord, I understand that you're resurfacing your pool in the hot month of June, and it's going to take about a month to complete. Now, according to my lease, this building, Mr. Landlord, comes with a swimming pool. I don't have a pool to swim in. Your comments, please?
My comment is that if the pool needs to be resurfaced, and that's a necessary repair, that the tenant has to provide the access, which means stay out of the pool. And there is no compensation for that. For example, let's pretend that you buy a brand new car.
Which you do about every 3 weeks. Go ahead, yeah.
I do not. But in any event, I did buy a new car not too long ago.
What'd you get, by the way?
Huh? I got a convertible Mercedes.
Very nice. Very nice. You know why, folks? Because he's at this office at 4:30, 7 days a week. 4:30 a.m. 7 days a week. So nobody's given this guy anything. He's
actually about 5:15.
5:15.
But that is true. So let's pretend you buy a new car and they give you a warranty. Just like a landlord is responsible for the warranty of habitability, you have a car manufacturer that's responsible for the warranty for the automobile. Now, if something goes wrong with that car, okay, the the response is that you bring your car in, you get it serviced, and you have to be inconvenienced by not having a car for the time that it needs to be serviced. Now, your position might be, hey, wait a second. I'm on a lease or I paid for this car. Now you're taking this car from me, even though you're fixing it.
I don't know about you. When I bring my car into service, I drive a Lexus. They give me a loaner.
Yes, but they don't have to give you a loaner. They're doing that for good client relations. So in that situation, you're going to take an Uber. You're going to get home. Someone's going to be waiting for you. And then you got to figure out a way to get back to the dealership once the car is repaired. Okay. And that's the same thing with the doctrine of habitability. For a landlord, you've got to allow him access to do the work. Okay. Quite frankly, we're living in an upside-down world where here the landlord, in the past, people would make the claim, landlords aren't fixing things. We need to have this doctrine of habitability that we can withhold rent because the landlord is refusing to make the repairs. Here, we have a situation where the landlord is making the repairs, and this tenant is saying, I'm not going to move my car from the parking lot unless I get compensated. Well, here's a message to that tenant who refuses to move their car when the work needs to be done. And that is, we're going to tow your vehicle, okay? And you can pay for the towing charges because we gave you proper notice. You have to give us access. And if you don't allow us to fix the parking lot where your car is going to be and you're demanding something else, number one, that takes a lot of chutzpah, and you can look that word up. But in any event, the tenant...
For the Gentiles out there, that's CHU, P for Peter, T for Tom, Z for Zebra, A. Go ahead, please.
Thank you for spelling that. But in any event, I would advise the landlord not to give any compensation and to have the car towed if it's still there. And you should warn the tenant that that's exactly what you're going to do.
Okay, Dennis, on that lovely note, I believe we're going to wrap it up. And as always, why don't you tell our podcast listeners how to reach you?
Well, first of all, I want to tell you that I really enjoy doing these video podcasts.
Absolutely.
They're a lot of fun. You can still listen to just the...
Can I take that new car for a spin on a weekend sometime?
Well, anytime you like.
Thank you. I appreciate that.
You heard it.
You heard it, folks.
Well, it's recorded. I can't even take it back now.
You can't retract it.
I can't. But anyway, I do enjoy doing these podcasts, and anybody can see them on either Facebook.com, that's Evict123, or on my website, or on my Twitter, which is twitter.com/DennisBlock. If anybody needs to reach me at the office, I got a toll-free number. It's 1-800-77-EVICT. That's EVICT. My website, where I've got all my forms, my podcasts, legal issues. There's just so much stuff for landlords to learn, all at no charge, is evict123.com. I would be remiss if I didn't tell you that I deal with so many management companies who hire my firm, but the Zachary Lawrence of Parkside Properties is an unbelievable management company. I deal with them personally, and I'm not just saying that because he's sitting next to me with a knife underneath the table here. Please, don't bug me. But he is great, and his website is parkside123.com, and I really encourage everybody, if you're thinking of having your property managed, this is the man to do it.
Thank you, Dennis. And once again, I'm Zachary Lawrence of Parkside Property Management, parkside123.com, saying so long. See you next time on the Landlord Tenant Radio Podcast. Dennis Block, good afternoon.
And this is the time I'm going to get up to end this podcast.
There we go.